Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about a case pending before the United States Supreme Court. It is a big case. It is the granddaddy of them all. If this case was a mountain, it would be the Mount Everest of cases. It's a case that will clearly and once and for all answer a very important inquiry as it relates to our Second Amendment rights, and it is this close to being accepted by the United States Supreme Court. Well, the state that passed the civilian disarmament law has now filed their response brief, and that's what we're going to go through today. So, take a deep breath. Here we go. Let's spend a few minutes and let's talk about the magazine ban case from hell. Okay, America, we have talked about this issue a million times here at Washington Gun Law. We are talking about magazine bans. The case we are talking about is, in fact, the granddaddy of them all, Duncan v. Bonta. Now, I want you to understand that this case was filed in 2017, or roughly 4 years before we ever started this channel. So this case is actually twice as old as Washington Gun Law. As you know, one of the things we try to pride ourselves on around here is that we try to keep things right down the middle, try to stay really educational in nature. And so if I agree with portions of the state's memorandum, I will point that out. And I would like to start with one part of the state of California's brief, the only part, as a matter of fact, that I agree with, which is how they present the issue. Whether California's restrictions on firearm magazines capable of holding more than 10 rounds of ammunition violate the Second Amendment or the Takings Clause of the Fifth Amendment. Now, there are a lot of very creative, actually completely crazy arguments here, because after all, this is the state of California. But I want you to know that the state of California can at least make these arguments with a mildly more straight face now, because once again, this brief will be sprinkled with a heavy dose of,
"You got Rahimi'd."
I mean, after all, the state of California begins it this way. Last year, the court clarified Bruin's framework in United States v. Rahimi. Some courts had misunderstood Bruin's methodology. The court made clear that Bruin was not meant to suggest a law trapped in amber. And with that, away we go. Now, there is a lot of diverting attempted here by the state of California, where they're basically saying, listen, Supreme Court, you're not even interested in this. I mean, take a look at how you've acted to these issues yourself. So why bother? This is one of the arguments. The principal question presented by petitioners is whether California's restrictions on large capacity magazines violate the Second Amendment. But the court recently denied 3 petitions raising materially indistinguishable questions concerning large capacity magazines. Petitioners provide no sensible reason to depart from that course and grant review here. And as you can see, all the cases cited by the state of California cases that we have covered here at Washington Gun Law. And in a case that actually defines the word percolation, actually more like aging like fine wine, the state of California actually suggests that it needs more of it. They state, the court would also benefit from awaiting further development in the lower courts of Second Amendment doctrine more generally. In the past few years, the court has issued 2 landmark decisions clarifying the framework for Second Amendment claims. Yes, they have, but none of you seem to understand it, or you do understand it, you just intentionally ignore it. Another argument they made, and we've actually talked about this on the channel here, is we got 2 Second Amendment cases already that have been accepted for review by the United States Supreme Court. Are they going to actually take a third? Well, the state of California asks that very same question. And the court just recently granted certiorari in a separate case presenting a Second Amendment question. The court does not usually rush to answer questions concerning the effect of recent precedent in the absence of a profound conflict among the circuits. No, but there seems to be profound conflict amongst the circuits and the Supreme Court, where many of the circuits do not want to follow the Supreme Court precedent. Now, the petitioners in this case, those representing Duncan, had raised several issues, one of which being is that there is a circuit split as to whether or not magazines even constitute arms under the Second Amendment. The state of California believes that's kind of ridiculous. Petitioners first contend that the decision below deepens a circuit split over whether, and if so, which magazines are arms. But then they go on and say, well, it's really not even that important that we find that, because there's other ways that these can be banned anyhow. And some of these courts just really didn't reach that decision. Don't believe what you read, as they put it. In 2 of the 4 remaining decisions cited by the petitioners, one of which predated Bruin, the courts of appeals merely assumed, without deciding, that large capacity magazines are entitled to Second Amendment protection. Then, of course, they have to take on the common use test, because that is the central component and really the beginning and the end of the inquiry here. They frame it this way. Petitioners next allege two conflicts related to this court's references in Bruin and Heller to weapons in common use today for self-defense. Well, you're wrong there already. It is not weapons in common use for self-defense. It is weapons in common use for any lawful purpose. But there is a significant disagreement about whether or not that is part of the text or the historical analysis. But again, the state of California believes it's really not a big deal. Why bother? The resolution of that question would make no difference to the outcome here, because the Court of Appeals gave petitioners the benefit of the doubt and resolved the common use inquiry in the historical analysis. And then, of course, they have to take on the central issue with the common use test, which is that, well, if in common use, it can't be banned. As they frame the issue, finally, petitioners contend that the lower courts disagree about the substance of the common use inquiry. And again, proving that this inquiry, this constitutional inquiry about what state legislators can do is really just no big deal. And this is literally how the state of California acts throughout this entire response brief here. It's no big deal. They're just sloughing it off. They put it this way. The decision below rejected petitioners' sweeping contention that the Second Amendment never permits a legislature to ban a firearm or accessory, provided that enough people purchased it before a legislature could act. Other courts have reached the same conclusion. No, you see, that is exactly the issue here, because if the American people have in fact chosen it as a tool for whatever lawful purpose it may be, under the common use doctrine, it cannot be banned. Let us also remember that the Ninth Circuit here actually found that magazines were not covered by the Second Amendment whatsoever because they were not arms. They were merely accoutrements. Now, obviously, the state of California agrees with that, but again, they make it seem to the Supreme Court that this is really not a very important inquiry. The Court of Appeals correctly held that large capacity magazines are not materially dissimilar from cartridge cases or boxes historically included in the category accoutrements. Petitioners do not contest that 18th century authorities distinguish between arms and accoutrements. Instead, they argue that the Court of Appeals placed large capacity magazines on the wrong side of the line. But petitioners' disagreement with the resolution of that narrow question does not warrant certiorari. No, you see, actually, resolution of that narrow inquiry, as you put it, is the exact reason this case should be accepted for review. Oh, okay, and then the state of California has to argue that, hey, listen, we know the test supposedly is dangerous and unusual, but it doesn't really mean what it says, because they argue, in each of those cases, the court referred to a tradition of restricting dangerous and unusual weapons, meaning weapons that are unusually dangerous. So with the common use doctrine not really meaning what it says, with dangerous and unusual not meaning really what it says, that means, of course, we have to go on our own independent historical inquiry, which, of course, sets all of us up for another chapter of
You Got Rahimi'd.
Because the state of California states, but neither Bruin nor Rahimi demands a historical twin, especially in cases implicating unprecedented societal concerns or dramatic technological changes. And then finally, and this is the very unique part to what happened in California, there is a whole separate argument here under the Fifth Amendment and the takings clause, because you got to remember, in California, you can't possess these things. So you either got to alter them, destroy them, surrender them, or sell them out of state. Do you get any just compensation for that? Of course you don't. I want you to know that the state of California basically likens what happens to magazines as if the state of California, if they would ever do this again, would make a substance, now a controlled substance, and illegal. They're not going to reimburse you suddenly for all the illegal drugs that you're now in possession of. That's literally the argument they make. Okay, we're going to go ahead and link up the state of California's response brief down below so you can geek out on it for yourself. Now remember, this is going to be a little infuriating, so let's either get 3 fingers of bourbon, do some breathing exercises, or bring a barf bag with you. We will wait to see. The case is scheduled for conference, so as soon as we get closer to conference, we'll talk about this case again. In the meantime, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, there's a link in the description box on how to do that. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. and stay safe.